now convened in criminals number 12474, 12390, 12389, which respectively are captioned the State of Iowa versus Valerie Louise Coolers. Is that how you say your name, ma'am?
Yeah.
And Rodney Lee Coolers. Is that how I say your name?
Correct.
You are husband and wife, true?
Yes.
All right. John Laughlin is seated next to you. He's your lawyer. I've talked to John about this, and he's made it clear that he's talked to the court before about this, but I'm not suggesting there's any conflict of interest and that your potential respective rights might be compromised by having the same lawyer. But have you talked about that with him?
Yes.
And you want him to be your lawyer?
Yes.
Both of your lawyers. And you feel that he's informed you of that problem or potential problem. True or false?
True. Correct.
Right. Ben Smith is here representing Sac County, and we're here today to proceed to judgment subsequent to the parties having pled guilty to a couple of charges. Ms. Coolers has pled to possession of intent to deliver less than 5 grams in violation of Iowa Code Section 401C6, and forgery, which is a Class D felony. The original charge is a Class C felony, and the forgery is a Class D felony. Now, I should point out to you that the Class C felony carries with it the potential of a 10-year jail sentence. And keep in mind, if you're sent to prison, you've got to serve 1/3 of it. I don't want to bypass that from the very beginning. And sir, you're charged with that same Class C felony as well. You understand that? Okay. There is a pre-sentence evaluation prepared by the court that I've gone through. I'm unaware that there's a post-plea evaluation made, so what I'm looking at would be pre-plea. Mr. Smith, would that be an accurate assessment of these reports?
That's an accurate assessment, Your Honor. There is no post-plea
Sentence.
sentence.
Mr. Laughlin, do you agree with that?
I do, Your Honor. Thank you.
Okay. Mr. Laughlin, have you received a copy of this report? Do you know what's in it, and do you object to its use?
I have received a copy, I know what's in it, I do not object to its use, and I've gone over it with my clients.
You don't know of any corrections or additions other than the procedural matters that took place that need to be brought to my attention?
I do not.
All right. Folks, you've heard your lawyer speak for you, but it's important that I hear it from you. Have you seen these reports? Ma'am, I'll speak to you first. Yes or no?
Yes.
Sir, have you seen this report?
Yes.
Do you care if I use it in my consideration?
No,
That's okay?
That's fine.
Mr. Smith, have you received a copy of these reports that are corrections, and do you object to its use?
Your Honor, the state has received the reports. The state has no objections, corrections, or additions.
Do you have any evidence you want us to provide to the court?
No evidence, Your Honor.
All right. Mr. Laughlin, do you have any evidence?
No, Your Honor.
All right, I have here the state's sentencing recommendation. Please.
The state sentencing recommendation in this case, Your Honor, has changed from the inception of this case to where we're at here today. Originally, the state had been requesting and had been arguing for a suspended sentence with certain other conditions and findings by the court. In light of information that was obtained just recently, and considering the fact that both defendants one of the defendants has pled guilty to an underlying misdemeanor charge and has served a significant amount of jail time, and the other defendant will most likely be doing the same. It's the state's recommendation that the judgment and sentence in this case, as it relates to these charges that we're here for today, be deferred and defendants be given the opportunity to prove to this court that everything that is not said about them in the pre-sentence investigation is true. So That is a departure from previous arrangements. The state, myself in particular, I believe in giving people second chances, and I can't deny the fact that there is no previous record. I can't also deny that that this is a serious crime. So it's the state's position that that the court consider a deferred judgment if the court believes that that is what's best for this case, for this county, and it is in furtherance of justice. So that would be the state's position.
Mr. Laughlin, how do you feel about it?
Thank you, Your Honor. We agree with a lot of things that the county attorney said, most notably that neither one of these folks has any record as reflected by the PSI or the pre-plea PSI. I would note for the court that both of these folks immediately got into substance treatment when they were arrested and released almost a year ago. I think it was in January. Successfully completed that. Have done well in the community since then, are both employed, have the support of their families, and have been good citizens since this occurred, as they were up to and before these events occurred. So, to me, Your Honor, that is what a deferred judgment is for. It's for persons who come before this court for the first time with circumstances that would support giving them a second chance. These are not young folks. They're not 19-year-olds coming in here a year after they turned 18 and getting arrested for something. They've successfully worked their way through adulthood for the most part without getting in trouble. And so, again, to me, that makes them good candidates for this type of a break from the court. And they've done well since this occurred. We're 10 months out now. Again, demonstrating to the court that they're good candidates. To me, Your Honor, there's really no reason not to give them that break, given what's happened and what's occurred, even though the charges were serious. They got right into the substance treatment and benefited from it, and have solved that problem, and we appreciate the court's consideration in granting their requests for deferred judgments in these cases. Thank you.
Ms. Coolers, it's called allocution of sentence. It's a big fancy word for DA. Is there anything you want to say in your own behalf?
No, you pretty much summed up everything.
And Mr. Coolers, anything you want to say?
I agree with that, Jimmy.
Well, let's talk about these charges for a minute. You're both charged with the Class C felony. You can be fined $1,000 minimally, $50,000 maximum, 35% surcharge. Court costs, attorney fees, restitution are all applicable. You may be privately employed, right, Joe?
I am, Your Honor. Thank you.
Okay. Driver's license suspended for 180 days, a $10 dare surcharge, a $125 law enforcement initiative fee. They're all applicable in this case. And if you're sent to prison, you have to serve 1/3 of it. There's no choice. Now, Ms. Coolers, you are also found guilty and pled guilty to a Class D felony. You can be sent to prison for 5 years, fined $750. It's a Class D felony, $750 minimum, $7,500 maximum, 35% surcharge, 35% surcharge added to that. Court costs, attorney fees, and restitution may be an issue in a forgery case. And since you have 2 charges, they can be sent consecutively or concurrently. Do you know the difference?
Yeah.
Okay. So a lot of things can happen. And even if I follow the recommendation of the state, a lot of things can still happen. In fact, regardless of my decision today, pretty much anything that happens to you from the moment you get up and walk out of here is going to rest in your hands, either good or bad. Even if I send you to prison. If I send you to prison, that could be affected by as much as 1/2 because of work credits and good conduct, and you could be paroled prior to the expiration of the full term. Purpose of going over all of this at this time is to remind you that there's a great deal of uncertainty as to what happens to you, but the best that can happen to you is if you really toe the mark here. I've sat through these things for a long time. I've done this for 20 years. I've listened to the sentence, and I've watched somebody drag out what they thought was going to be some sort of a big surprise. I'm going to give you both deferred judgments. There's no sense in beating around the bush with it, but I want to talk to you about it for a minute. Some time ago, many years ago, over 20 years ago, somebody decided that was a good idea to give a deferred judgment. And it gave an opportunity for someone that deserved a break to have a reward. And in doing so, it was intended to benefit you, but collaterally it benefited everybody, the public. I've served no purpose in sentencing you today. The purpose of a sentence is to protect the community from further harm and provide the best opportunity for your rehabilitation. And I've failed if I don't address both of those issues. I failed my neighbors if you go out and re-offend. I failed you if I don't give you a chance to get better. Sounds simple, but it's kind of complicated. But we're all the beneficiaries of you succeeding. So if you think I'm wishing you fail so I can send you to prison, you're mistaken. I want you to succeed. Now, I rely a lot on these pre-sentence investigations, and I make notes on every one I read. And I look through this, and I told your lawyers in the chambers that I come up with the word that I've heard used by people smarter than me. Your record is unremarkable. In other words, there's nothing in your past that suggests you should be here today. You have no past record. You're old enough to have established a long record, but you haven't. Something happened. Something bad happened to you in a small period of time that got you here today. And I'm hoping that your past, your long past, is representative of the type of people that you are. That you do recognize that there are laws that are important to obey. And like I say, something happened. If I knew how and why these things happen, I could be a lot more effective in a lot of places, but I don't. Like I say, you have no previous record. You're both capable of working. I think, sir, you're full-time employed right now, right?
Correct.
And ma'am, do you work as well?
Yes.
All right. You've addressed your issue voluntarily. You both went to counseling and rehab. Are you following through on that?
Yes.
Are you successful?
No. Yes.
All right. I'm going to ask you a question right now, and be honest, because we're wasting time. Are you going to succeed at this? I mean, are you going to go out and you're going to start using drugs again and selling and seeing whether you can get by with it? Because if you are, we might as well just, go right square to the beginning and get started with it. Are you going to make it, ma'am?
Yes.
Sir?
Yes.
Are you supportive of each other?
Very much.
Okay. Would you stop the other one if you saw them doing something bad?
Definitely.
I think sometimes the public and people that watch or hear about these sentencing things that the important thing is to punish. And I'm a believer in second chances. I don't measure a person's worth by the mistakes they've made, but rather how they react to them. And we all make mistakes. And if I send you to prison today, what I've proven is that I have the power to do that. Now, I'm gonna go out on a limb for you. Are you gonna prove that my judgment is sound today, ma'am?
Yeah.
Sir?
Yes.
As relates to the state of Iowa versus Rodney Lee Coolers. The judgment is deferred in your case, and there will be no civil penalty. Is that correct, Mr. Smith? Or are you wanting one?
I'm asking for a civil penalty, but it be suspended along with the, just.
All right, it'll be a $1,000 civil penalty that's suspended. You'll be required to pay the court costs. If there's any restitution involved in your matter, Mr. Cooler, you're going to be required to pay that as well. You're privately employed, your attorney, and you're going to be placed on probation. How long a period of time do you want to know, Mr. Smith?
The state would ask that both defendants be placed on probation for a period of 2 years.
All right, 2-year probation. With the Second Judicial District Department of Correctional Services being the supervising agency, you'll contact this agency within 10 days, sir, to arrange the probation and pay the fees associated with it. Keep in mind you'll be expected to obey all the laws of the state of Iowa. You'll comply with any other terms and conditions that they may impose upon you. You'll submit a specimen for DNA profiling. You'll be required to enroll yourself in any additional substance abuse programs and evaluation that they determine to be appropriate. Do you know anything I ought to add to this, Mr. Smith?
No, Your Honor.
Ms. Schoolers, a similar sentence will be imposed upon you. There'll be a $10 dare surcharge also imposed. I may not have said that.
I believe, Your Honor, also, maybe you did mention it, but I believe DNA profiling is still applicable.
I did.
You did mention
say
that. My apologies.
I'll go through it one more time for you, ma'am. Your sentence shall be deferred, and in your case, the $1,000 civil penalty will be suspended, as will the $750 for the aggregate or for the Class D felony, and you'll be subjected to supervision for 2 years by the Department of Correctional Services, obeying all the laws, contacting them within 10 days, paying the cost of the supervision, and you will submit for a DNA profiling. What led us here today was a complicated set of facts that involved your mental stability. There was a lot of consideration to charges, amendments, very complicated stuff, and it's reduced itself down to a pretty simple matter today, one that some may think is too simple. The burden is upon you now, folks. You can take credit for the success that I hope you enjoy, but you're also going to have to bear the consequences of your failures. And you will be back in here, and the likelihood to find a sympathetic ear at that time if you foul up, if you make a mistake, is small. And you're likely to go to prison, and you're likely to serve the 1/3. And you know what? And the county attorney, he's gone out on a limb here to do it. I mean, it'd be real simple for him to object, to resist, but he's a smart guy, and he understands the purpose of a deferred judgment. He's placing some faith in you as well. I'm making the call, but he is also saying, you know, you folks might deserve it. And I'm sure there's a part of him that a little hesitant. I got that message from him in Chambers. So I don't know. I've never known whether it's appropriate to thank a county attorney, but you might nod at him and say, you know, I'm not going to make you look bad. I'm going to live up to my end of the bargain. That's all we ask, folks. The appeal is not appropriate at this time because it's not a final judgment.
May I just add for a second?
Yeah.
One, restitution as to the underlying theft charge and the aggravated that's yet to be dealt with is not an issue in this case, but I just need to make the record that there's an acknowledgement from defense counsel that will be addressed in the aggravated misdemeanor.
That's my understanding.
Okay.
Okay.
And the second thing is too, and I appreciate the acknowledgements by this court, but this court also knows that that my office does take revocations very seriously and has and will prosecute extreme prejudice, any foul-ups. So just wanted to add that.
I probably should have told you that too. I've seen him come back when it hasn't worked out quite so well, and he's not nearly as benevolent. Just don't come back. All right. Good luck to you.
Thank you, Judge.
Yes, sir. See counsel in chambers listening. I'm sure we got some